The notice from the county came in a plain envelope. Your mother almost threw it out. It is an assessment notice, and one line on it matters. $810,000. Her house is paid off. She is $58,000 over the line, and last month Medicaid denied her. She is 79, and she has lived in that house since 1974. There has not been a mortgage payment on it in 20 years. Every person who ever gave her advice told her that was the smart thing to do. It was the smart thing to do. That is what makes this so hard to explain to her. Because a home is not simply exempt from Medicaid or counted by it. Every home is exempt on conditions. There is a list of them, and the day she applied, one of them stopped being true. She had no idea there was a list. Neither did her daughter, who filled out the application at the kitchen table and thought the hard part was finding the bank statements. Here is what that denial actually costs, and it is not theoretical. A private room in a nursing home now runs $129,575 a year. Those numbers come from the 2025 Cost of Care Survey, published this March. Call it a little under $11,000 a month. While an application sits denied, that money comes out of savings, not out of Medicaid, out of whatever your mother has left. So the $58,000 she was over by is not an abstraction. At $11,000 a month, $58,000 is about 5.5 months of care. She was denied over a number that private payment burns through by spring. Now here is the part I want you to hold on to. There are 5 separate things that make Medicaid count a paid-off home. 5, and 4 of them have nothing at all to do with what the house is worth. Most families only ever hear about the first one because it is the only one with a dollar sign attached. 4 others are the ones that actually catch people. One of them is a single sentence that nobody at the office will tell you to say. Start with the thing that gets confused more than anything else in this whole subject. Medicare and Medicaid are not the same program, and only one of them is in this story. Medicare is the insurance your mother paid into every working year of her life. Medicare covers hospitals and doctors. What Medicare does not pay for is long-term nursing home care beyond a short rehabilitation window. Medicaid does. Medicaid is a means-tested benefit, which means it looks at what she owns before it agrees to pay anything. And when it looks, it sorts everything she owns into 2 piles, countable and exempt. Her checking account is countable. A wedding ring is exempt. Most states hold the countable pile to about $2,000 for a single applicant. The home usually sits in the exempt pile. Folklore gets that part right. What is missing from the folklore is the word usually. Federal law sets a hard ceiling on how much equity a home can carry and still stay exempt. For 2026, that ceiling is $752,000 in most states. A little over a dozen states elected a higher one, at $1,130,000. The figures come from the federal standards published in December for this year. Notice the word equity, not value. Equity is what the house is worth minus what is still owed on it. Take a $900,000 house with a $400,000 mortgage on it. That is $500,000 in equity and nowhere near the ceiling. Your mother, who did the responsible thing and paid hers off, has all of it. That is the cruelty in the arithmetic, and it is worth saying plainly. Paying off the mortgage is what moved her over the line. So that is the first of the 5, and it is the one everybody knows. Now let me show you what a denial actually looks like when the number was never the problem. There is a second family I want you to think about, because their house was worth $420,000. Nowhere near any ceiling in any state. The father went into a nursing home in February after a fall. His wife had died 3 years earlier. Both children live out of state. The house sat empty, and his daughter, being practical, wrote on the application that he had moved out. That sentence was the whole case. For an unmarried applicant with no qualifying relative living in the home stays exempt on one thing: a stated intent to return. She never stated it because nobody told her it existed. She wrote the opposite by accident, in her own handwriting, trying to be accurate. $420,000 moved from the exempt pile to the countable pile, on the strength of one line. Against a $2,000 limit, the arithmetic is not close. He was turned down. Nothing about that house had changed. Not the value, not the deed, not the neighborhood, only what the paperwork said about whether he was coming back. So if the number is only one of 5, what are the other 4, and what do you actually do about each one? That is the rest of this video, and I promised you 5. Here they are, all 5, and what to say for each. Number 1. Equity above the ceiling. Your job is to find out which figure your state actually uses. The assessor's number and fair market value are frequently not the same. Between the two, tens of thousands of dollars. Ask the caseworker this, in writing. Which valuation does the agency use to determine home equity, and may I have that in writing? Put it in the application file. An assessment notice is not a determination. Number 2. Nobody protected is living there. Federal law says the equity ceiling does not apply at all in 3 cases. A spouse lawfully residing in the home, a child under 21, a blind or permanently and totally disabled child of any age, not partly. It does not apply. If that describes your family, say this: my son resides in the home, and I am claiming the exception under the home equity provision. Bring proof of residence, a driver's license, a utility bill, a piece of mail with that address on it. Number 3, and this is the one from the story. Intent to return. Ask for the intent to return statement by name, and ask before anyone writes a word about where your mother is living now. In most states, it is a short signed sentence. You pay nothing for it. Signing takes 1 minute, and no attorney is required. Number 4, the clock on that statement. Some states honor an intent to return indefinitely. Others allow it only for a set period, and Virginia is the example most often cited. Ask this exactly: does this state place a time limit on an intent to return, and what is that limit? Then write the date on a calendar where somebody will see it. Number 5, the word permanent. Nobody should describe the move as permanent on any form until your family understands what that word does. Saying she intends to return is honest, if it is true. And the difference between an exempt house and a countable one can be that one sentence. 4 of those 5 cost nothing and require no lawyer. That is not a coincidence. It is why I wanted you to know all 5. Now the honest part, because a shield you cannot see the edges of is not a shield. Federal law requires a hardship process. If applying the equity ceiling would cause a demonstrated hardship, the rule can be waived. Hardship is real, and it is written into the statute. Hardship is also slow, discretionary, and not something to plan around. Treat it as a last door, not a first one. Second, one date you should know. On the 1st of January 2028, the ceiling changes. From that day, it is a flat $1 million everywhere, and no longer rising with inflation the way the current figures do. Homes on agricultural land keep the old indexed limits. That is nearly 2.5 years away, and it is not a reason to do anything today. Knowing about it now is how you avoid being surprised later. Third, and this is the one that matters most, these rules are administered state by state, and the differences are not small. Federal law sets the ceiling. What differs is which valuation your state uses, whether it time limits an intent to return, what proof it accepts for who lives in the home. Some states are generous with all 3, some are not. One more reason this conversation has to happen with someone who knows your specific state's rules, and not a national average. I am not a lawyer, and I am not your caseworker. There is one more thing worth saying out loud. Nothing here is about hiding a house. Every one of the 5 is about getting the record right before somebody else fills it in wrong. So let me put the 5 back in your hands, in order. 1. Equity above your state's ceiling. 2. No spouse, minor child, or disabled child living in the home. 3. No stated intent to return. 4. An intent to return that timed out. 5. A move recorded as permanent. One of those is about money. 4 of them are about paperwork, and paperwork is the part you can still change. Here is the one thing to do today before you go to bed. Find out whether your mother has ever signed an intent to return statement. If the answer is no, or you do not know, call the county Medicaid office tomorrow morning and ask for it by name. That is the whole task. One question, one form, no money. If this was useful, please like this video and subscribe so the next one finds you. It genuinely helps this reach the families it needs to reach. And I will say to you what I always say, I would rather you act a year early than a single day late. Take care of yourself and take care of her.